say the better, but if you can be succinct and as precise as possible, it would be good because we have limited time and we know that we will have a lot of questions in this particular discussion. We look forward to a live engagement. Do smile, be happy. Yes. And in case of anything, I know most of you have been now, so just WhatsApp me. All right.
So we go like all from the silent.
Is that fine? Are we okay? Okay, thanks, Julie, for the water. Are we okay? I look at this camera.
So we go live.
Okay, but I look at this one. Okay, thank you.
So we go live in 5, 4, 3, 2, 1, live. Go.
Good morning. Thank you for joining us this morning. Tomorrow, the world will mark the World Day Against the Death Penalty, a day that has been set aside to advocate for the abolition of the death penalty and to raise awareness on the conditions and the circumstances which affect prisoners with death sentences. The theme for this year's commemoration is centered on the access to legal representation for prisoners on death row. Kenya has not carried out an execution for over 30 years. Thousands, however, remain on death row and continue to be sentenced to death due to the automatic nature of the death penalty. In this regard, ICJ Kenya, in partnership with Amnesty International, will engage you, our listener, in an in-depth discussion on the right to legal representation in death penalties in Kenya. We also invite you to share with us your comments and questions in the chat section. Please feel free to call in and engage our panelists on the same. I will hand over to my co-moderator, Julie Matheka. Welcome, Julie.
All right, thank you very much. As mentioned, my name is Julie Matheka. Both of us work at the Kenya section of the International Commission of Jurists. We are happy to have with us a distinguished panel of experts who will be guiding us in this discussion. So to join us and to rather engage us on this robust discussion, we have renowned human rights activist, Wilson Kinyua, who will be representing us in this discussion. We will also have with us Madam Li Fang, a senior human rights advisor with the Office of the UN Human Rights Commission on Human Rights. Ms. Li Fang will be sharing with us international perspectives on the death penalty. Ms. Flora Bidali, the Acting Executive Director of the National Legal Aid Service in Kenya, an institution with a constitutional mandate to provide legal services in Kenya, will be speaking on legal representation in Kenya for persons on the death row. Next, we'll be joined by Mr. Kevin Mwangi, who will be joining us a bit later, who's an expert member at the ACPHR Working Group on Death Penalty. He will enlighten us on the work of the Committee on the Abolition of the Death Penalty in this region and across Africa, of course. We'll also be joined by Ms. Ruth Kiama, a litigation officer with the Center for Human Rights Education, Advice and Assistance, an organization based in Malawi, and one which has been providing legal services to death row inmates as part of the implementation of the resentencing project in Malawi. We also have, and finally we have with us, Mr. Dimas Kiprono, who will be shedding light from the civil society perspective, and he works with Amnesty International Kenya. He will be explaining to us what has been the situation in regards to Amnesty and its advocacy around the abolition of the death penalty in Kenya, in Africa, and across the world. So to all our panelists, thank you very much for joining us today. We are glad that you could spare this time and in commemoration of the bigger day. Should you have any questions and observations, as my colleague has mentioned, please do send them in the chat section, and at some point we will be able to engage with that. And you can also call in by informing our technical team on the same. We wish for you to follow us on our various social media platforms at ICJ Kenya on Twitter, on YouTube. We also have with us the World Coalition Against the Death Penalty, which you can follow on Twitter and on YouTube. Lastly, of course, our partner, Amnesty International Kenya, who speaks to security, human rights, and other issues. You can follow them on their Twitter platform for more and engaging, robust discussions. So we will begin this conversation now with a perspective sharing from Mr. Wilson Kinyua. You have been, I would say, a person who can best elaborate on the issues around the death penalty. So having been incarcerated in Kenya, what are the experiences in accessing legal representation throughout the trial? And what gaps would you identify as hindrances to effective legal representation? Over to you, Mr. Wilson Kinyua. Asante.
Audience, like you've heard, my name is Wilson Kinyua, and I was sentenced to death when I was a teenager of 19 years old. That was back in 1998. I have lived in prison, stayed in prison for 21 years. I left prison last year, so I'm only 1 year old since I left prison. So much of my life is actually what I've lived in prison, and I was on death penalty. The first experience is that I was a country boy. I'd never lived an urban life. I never knew anything to do with court proceedings, anything to do with the law and lawyers, none of that stuff. But here, I am only, okay, in Nairobi, I was only 3 months since I left the upcountry to come and join Strathmore to do accounts. And that's when I met the fate. And I am now taken to court with a case of robbery with violence, and I'm supposed to defend myself. Even the very word defense was a new vocabulary to me. I don't know what that entails, and I'm supposed to defend myself. I don't know which question I should ask, and I'm pitted against a very competent prosecutor. I do not have a background that can support me with, to be able to hire a lawyer. And at those times, it was the height of the degeneration of judicial, the degeneration of confidence in the judiciary. So actually, there was no confidence in the judiciary. There was a lot of corruption. There was a lot of things happening in the judiciary, like even justice was almost commercialized there. And therefore, I did not have money to buy justice, and I didn't have money to hire a lawyer. So I was taken through that kind of proceedings. You know more than any other person that in such a case, when you are supposed to be, in the event of conviction, you'll be sentenced to death. It's likely to cause a miscarriage of justice when you are not represented. And you say that garbage in, garbage out. So if I don't know what to say in court, I don't have the capacity to interrogate my case, even to ask questions. And that is the basis upon which the conviction will be, raised. Would you still say that somebody is guilty? Irrespective of me crying that I was guilty, I was innocent and all that, let's set aside that, because that is no longer important. But the system is important for any other person. So legal representation is very, very important for people who are actually facing such magnitude of charges. They need representation, people with the capacity to interrogate the case and to lay a good foundation. The subsequent appeals will be based on records, and judges has no opportunity to see witnesses, to see what the magistrate might call demeanor and all those things. And the biasness at that time. So judges, however, upright they are, they do not have that opportunity to see the witnesses, to hear you testify and all that. They base themselves on record. And therefore, anything that was not brought on record will not help you. There's little you're going to do to salvage your case if the foundation of the case is destroyed. So that is the process through which not only me, I'm just a practical example. A lot of people then, because that time in committee alone, we had over 4,000 inmates. 4,000 inmates going through that process. And the inmates hosted in were all faced with that kind of, capital charges. So upon conviction, and I lost all my appeals, I was to face the hangman, and I stayed there for another 11 years. waiting for the hangman. You don't know the hour, you don't know the minute, you don't know the day. You can imagine the magnitude of, psychological torture and all that. And again, the training of the prison officers by then was that these are not like human beings. These are not human beings. So the treatment is very dehumanizing. There is, significant transformation today in prison and in the judiciary and all those others. But I'm giving you a reference because I've gone through the two extremes when there was so much, a violation of prisoners' rights, and today when we can experience some remarkable transformation or changes or reforms in the prison. So I went through that, experience for 11 years, waiting for the hangman until 2009, when the former president commuted death penalty to life sentence for 4,000 inmates. 2009. Well, because I wanted to do CPA when I came to Nairobi, I decided to continue doing CPA when in prison. And I did up to section 3. I was supported by my brother, but I was on death row. Imagine, and the motivation behind that is that prison is overwhelmed by a population that is so illiterate, coming from a deprived background. They do not have education. So my Form 4 education was so big. And I was like the only person who could be able to read documents and interpret to the inmates and all that. And through that motivation, I kind of thought maybe I kind of, became a role model somehow. And because they are looking upon me, I could do something more to be able to help them. And that's when I started, because that is the only thing I could have done. I reached out to my brother and started paying for my course up to section 3. And that's when I met African Prison Project, who decided to sponsor my legal education. So I studied my diploma while in prison, and later they sponsored me to do degree, and which I graduated last year with the Bachelor of Laws degree. Now in 2010, let me give you a phenomenon somehow of how it really was, because when I'm telling you a population of 4,000 inmates, over 80% were young people, less than 20s. You can talk about 20s and below 20, 19, 18, because personally I was 19. And I started seeing younger than myself, 16, 17, 18 years in prison, very young people. And if you consider the content of the criminal responsibility that have earned them death penalty, you really see there is disconnect between what we want to achieve in the criminal justice system. That, of course, there is this much, expands the delinquency in the society, depending on how the society is. But do we have the solution as executing all these young people because they have robbed mobile phones, snatched some packed food, some cases of that nature, without that aggravated circumstance of hurting anyone? We say robbery with violence, but if you consider the element of violence, again, it's pathetic. What is it that we are calling violence? And I'm happy that we have moved from there, but it needs to be followed up. Granted, the outcomes of the resentencing and what is happening right now. Now, back to what I was saying. Now, we decided to launch a case challenging mandatory death threat. I know this is a case that is ICJ has contributed so much, and other civil society has contributed so much. But the history of this matter started in 2010. And the case that first challenged mandatory death penalty is the case of Francis Karioka, the case of Joseph Kaberia Kainga and 11 others. There's the reason why I'm revisiting that case, because I want to introduce some bit of experience in that case. We challenged mandatory death penalty in that case, and mandatory death sentence was declared unconstitutional in 2016 by a 3-judge bench, Justice Mutuku, Justice Kimaru, and Justice Receipt. And in 2017, that is when Muruateto case approved or upheld the decision of the decision of Joseph Kaberia Kainga and 11. And that is the case I represented. Personally, I was given an opportunity by judges to represent 12 inmates on behalf of all the inmates in the same circumstance. So I'm happy that Supreme case of Francis Kariko Mruatetu actually upheld the decision we helped, we initiated and succeeded. And the reason why we moved that direction of challenging mandatory death penalty, we know there is a challenge in abolishing death penalty. With the opinion of the people decide maybe we might, we should continue holding, having death penalty in the new constitution. But we discovered that the reason why people are supporting death penalty is because of misinformation. People are not getting the right information about death penalty. And therefore, they do not know why they should, they cannot relate with their decision why they should continue having death penalty in the Republic of Kenya. Because we have incidences that obviously shake, the people's conscience and all that. The case, the offenses committed by, for example, the people associated with Al-Shabaab and all that, where there's callous massacre of people and all that. And you want to put those people in the same basket with a boy who snatched a mobile phone on the street. People who just require a punishment, people who require to go through, a process of, a discipline and being taught how they can be able to live on their own, effort, on their own honest income. They can be trained. That can be inculcated in those young people. So there's a lot of misinformation, just giving to people the sensational cases only and not telling people how we can deal with them. So that is why we moved to the direction of challenging the mandatory nature first before we come to abolition of death sentence itself. And I know this is going to go through in the due course. The reason why I revisited that case of Joseph Kaberia, Kainga, and 11 others, we were challenging also the construction of robbery with violence. And that is a capital offense that earns death penalty. In that case, and those who have not led that case should lead that case because it has more fresh than a Mruatetu case, because we challenged all those aspects, even of mandatory, even of the construction of robbery with violence, offense, and even the attempted robbery. The reason why we are saying that legal representation is very important. In those cases, you'll be able to see that the framers of that law intended to graduate that offense into aggravated and simple robbery. But that dichotomy is not clear. That is why even from the very innocuous offense, you are sentenced to death. And that dichotomy was drawn clear by that decision, saying that that decision actually, explicated the situation and said, then there needs to be a reform in that case. The construction of that robbery is wrong, and convicting somebody under section 296(2) is unconstitutional. If you read that judgment, actually, I know there are robbery suspects who have refused to take plea until that reform has been done. And majority of those people who are involved in, pushing for reforms may not be aware because they have not led that case. The other one is about the attempted robbery. For a long time, attempted robbery should not have been earning death penalty. But inmates, because of lack of legal representation and lawyers who need to interrogate further, go-getter lawyers, we just don't need legal representation. We need effective legal representation. That's a challenge lawyers must take. We just don't need to have a lawyer in court. We need a lawyer who have sent himself, to do that which he need to do to facilitate justice. The attempted robbery should not have been earning death penalty. That has already been made clear. And these are part of the reforms that need to be done in the criminal law so that we can enhance the security that is embodied in the due process. We must ensure those people who should not suffer death penalty in the first place before we go even to challenging, the death penalty itself. Even those people who should not earn death penalty should not earn in the first place. That is the reforms that need to be done. The people who have earned, those people again who have been convicted of the death penalty should have a representation that really, somebody can be able to appreciate that he has gone through a fair process. We have been, together with the inmates who have committed suicide in prison, have taken their life because they cannot come into terms with the fact that they have been confirmed to be guilty when they are not guilty. Those kind of miscarriages of justice. And in Kenya, we would not want to go to that end, maybe as a government or something, because we don't want to see that egg on our face. People would rather keep that at the carpet than say there are people who have gone through that kind of unfair process. But we need people who can be bold enough to be able to push these reforms and ensure that the laws that embody the criminal justice system are enough to provide security for innocent people or innocent suspects despite their entanglement in the case. That only guilty people end up in prison. Before then we go to interrogate, when they go to prison, then what do we want with them? Do we need to break them? Do we need to transform them so that then this impacts to the apprehension of crime? Because mere execution of inmates do not earn the reduction of crime, the alleviation of crime. That is a statistic you have as expert. It is not happening. There is new perspectives of crime management we can pursue instead of executions. There are a lot of maladies in the law, and I was involved in drafting the recommendations of laws that should be reformed in the criminal justice system, including some of the gains we have gotten from through the Constitution that are not compatible with the criminal justice, the criminal procedure code. For example, we need the defendant need to be given evidence beforehand to be able to prepare, the prosecution evidence. So the criminal procedure code does not grant that. It is only in the Constitution. So when you want to ask for those proceedings, the magistrate will tell you to pay. And the majority of those people do not have money. So unless you have a lawyer who can say, yes, yes.
Thank you so much. Thank you so much for your insights. I really thank you for your invaluable contribution. You've highlighted quite a number of issues. And as we continue into this discussion, I really thank you for the contribution or the role you played, particularly in the Murotetu case in representing the inmates. The decision from the case was actually laudable and paved way for the establishment of a task force on death penalty in Kenya, a task force which has already shared its report. And one of the recommendations emanating from the task force is the need for the inmates on death row to be resentenced. Now, kindly allow me to invite Ms. Florence, representing the National Legal Aid Service in Kenya, to briefly highlight the progress that has been made by the National Legal Aid Service towards providing pro bono legal aid services to death row inmates in line with the recommendations by the task force on the death penalty. Welcome, Ms. Florence.
Good morning, and thank you for this opportunity. We have heard what Wilson has said on this death penalty, and mine is too. When you think of what Wilson Kinyua has presented, and we are in a developing country, let us look at what we refer to as the developed country has done when it comes to instances like what Wilson Kinyua has explained to us. I'll bring you a case that has happened in a developed world. About 31 years ago, a woman in her prime was walking in the Central Park, and she was brutally murdered. And she was also raped and brutally murdered and left for the dead. DNA samples were taken, and thereafter there are some 5 boys who were arrested and they were sentenced. They were on the death row. However, 7 to 8 years later, somebody else was arrested, and when they did their DNA, it turned out that that was the murderer and rapist of this same woman who these 5 boys had been convicted of. Now, when you look at this presentation by Mr. Kinyua and this Stropak, who was sentenced or crime he did not commit. Now, that tells you that access to justice has to be there. Now, if you look at from our part now, among Kinyuas who have gone through what similar instances like Kinyua in a developing country are there in a system that is said not to have the same level of investigation as, let's say, the developed world. Just a minute. Now, how do we come in as National Legal Aid Service to address access to justice? Now, the Legal Aid Service is established under the Legal Aid Act 2016 with a mandate to provide, facilitate, and coordinate the legal aid scheme in Kenya. And according to this act, legal aid includes the legal advice that we provide, legal representation, assistance in solving disputes, but that would not apply in the death penalty. And we also have legal aid providers who are going to guide us in this. Now, how is the National Legal Aid Service looking at this? We are looking at paralegals. The Act takes cognizance of paralegals. These paralegals are the people what Mr. Wilson Kinyua has just presented. The Legal Aid Act, among the legal aid providers that we have are paralegals, and these paralegals are defined as those employed either by the National Legal Aid Service or who have completed a training in the field of study in an institution approved by the Council of Legal Education. Why do I emphasize this training? It's so as to bring paralegals to a standard that is acceptable in addressing some of these legal issues. Paralegals, you can call them legal assistants. And now, in the Kenyan system, you see we have a tripartite system. We have the formal justice system, which is very technical and will require advocates who we have limited in the country. And other than that, how many of us can afford these services when it comes to these capital charges? You have heard what Mr. Wilson Kinyua has just presented. Then we have the informal justice system. This again may not apply in this death penalty. Having it in place, we hope to engage paralegals to create awareness to people in the society so that they will avoid certain matters that may end up ending in the justice system because they did not know that that should not have happened. And the third one is the Sharia system. And now, why do I emphasize on paralegals? Again, they are available at ground level, at grassroots level. They are the people to be in the prisons. They are the people who live with the community. They are the people who will make the reference to us the legal fraternity or the institutions in order to address any matter that may arise and create awareness. Generally, these paralegals are familiar with the local dynamics and customs and are aware of the existing laws and procedures, and they are responsible for legal literacy. Through paralegals, anybody who is charged will know that they are entitled to an advocate at state expense, and then we will have addressed access to justice for somebody who may not afford. The Act is also specific in the matters that legal aid services will be rendered to. Criminal matters are one of these, and they will be provided with an advocate, and having paralegals to create awareness on the ground will also bring this to the attention of anybody who may want our services. Then, eligibility for this legal aid again. The eligibility criteria, we talk of being a Kenyan citizen, maybe one is a child. You had Mr. Kenya talk of, there are those who were underage and they were not represented. Under the Legal Aid Act, they would be represented at state expense. Then we have refugees, again, who qualify for legal aid, victims of trafficking, the IDPs, the internally placed persons, and stateless persons, they are entitled to legal aid. Just a minute. Now, looking at what is happening in the system, it is important to note that without legal aid, then we will have a lot of injustice for people who may have not committed the crime. I saw one of the questions coming in when Mr. Kenya was presenting, and my thinking, just looking at the Legal Aid Act, is yes, people have been convicted. You may have committed the crime, you may not have committed the crime. But what we are looking at is not now whether you did or did not, is what evidence was used against you and how were you aware? What did you know that you ought to have known prior to that conviction? So as the Legal Aid Service, we are available and ready to work with anybody who would partner with us in creating access to justice. We are working with CBOs and PBOs, the faith-based organizations. We are in Nairobi, we are in Nakuru, we are in Eldoret, Kisumu, Mombasa, and we are rolling out our services to other regions. We have a toll-free line, which we intend to place at all prisons, at police stations, and various remand homes and various institutions, even chiefs' offices, so that access to justice can be rendered. And with that, I say we are available also on short notice, and please feel free to get in touch with us as we continue with these presentations. Thank you.
Very much, Flora. Indeed, we will get in touch with the National Legal Aid Service. It's a very important institution, and we do hope that most of the challenges that Wilson has raised will then be addressed by the full operationalization of the Legal Aid Act and the capacitation of the National Legal Aid Service. So thank you, Flora. We will definitely be roping you in, and particularly in the question and answer session. So I now wish to turn to Ms. Lee Fang. And my question to you, Ms. Lee, is what are the international perspectives on the death penalty, with a specific focus on the interplay between international law and the global trends towards abolishing the death penalty? Over to you, Madam Lee.
Thank you. The international position for the United Nations on the death penalty is pretty clear. The Secretary General himself has said that the death penalty has no place in the 21st century. And that's the clear position from the United Nations, and particularly from the Office of the High Commissioner for Human Rights. And we've consistently called for the universal abolition of the death penalty, because it is fundamentally not in sync with the fundamental nature of the right to life. There's also issues in terms of the risks of executing innocent people and the absence of proof that the death penalty even serves as any deterrent to crime. But I think from a rights-based perspective, it's very clear. In terms of movements on the international front, In December 2018, so close to 2 years ago, the General Assembly passed a resolution that was co-sponsored by 121 states on calling for a moratorium on the use of the death penalty. And I mean, this shows that there's a growing movement internationally amongst member states as well towards a moratorium, but then there's the move forward towards universal abolition. And the Secretary General has said that the moratorium and this resolution is welcome, but it's far from enough. And he has really committed the United Nations to work with member states and with civil society to advocate for the universal abolition of capital punishment. In terms of where the positions of states lie, there are around 170 states that have either abolished the death penalty or introduced a moratorium in law or in practice. And 21 of the 55 African Union member states have abolished the death penalty. Kenya is what is known as abolitionist in practice, with the non-execution policy that has been in place since 1987. But as we've heard, the mandatory death penalty still remains in the penal code. The position of the United Nations on the mandatory death penalty is that it should never be mandatory, not even for the most serious crimes. And also that states should refrain from, where states have retained the death penalty, that they should refrain from using it for crimes that do not involve intentional killing. And that would include the crimes of robbery with violence that are included under Kenyan law. But I think that on to what we're debating today, which is the issue of legal representation, I think that there are very clear connections between the death penalty, fair trial guarantees, and then the disproportionate impact on those who are the most vulnerable. And this has been highlighted by many UN senior officials and experts. As I've said, international human rights law calls for the abolition of the death penalty because the penalty itself violates the right to life. But international human rights law also opposes the inequity in the death penalty's application. According to the Human Rights Committee, which is the committee that oversees the International Covenant on Civil and Political Rights, the imposition of the death sentence after a trial in which due process and fair trial safeguards have not been respected, that in itself constitutes a violation of the right to life. And these circumstances, these examples include cases where there has been lack of effective representation during all stages of the criminal proceedings, as Mr. Kinyua spoke to in his case, having to represent oneself because there's no legal counsel available. And the Secretary General has voiced his support for this position. Coming on to the issue of inequalities, because I think that that's also something that we need to look at apart from the legal perspective. How do injustices affect those who are the most vulnerable? The issue of poverty makes people especially vulnerable to injustice more broadly. And the independent expert on poverty and human rights, Mr. Philip Alston, he has said before that the death penalty is reserved for the poor. And it's a reserve for those who cannot afford legal representation and cannot afford a decent appeal. And I think that this underscores the importance of legal representation, which is the topic being discussed today. My boss, the High Commissioner for Human Rights, Michelle Bachelet, has emphasized the links between the Sustainable Development Goals, what we're aiming for the country, the links between the SDGs, the poverty, rule of law, and the use of the death penalty, which is almost exclusively meted out against the poor worldwide. She has asked if we're unable to guarantee that the poor will receive justice and access to legal representation when their lives are at risk in the context of the death penalty, then how can we hope to provide the rule of law foundation that's actually needed to achieve the SDGs in countries? And I think this is important to reflect upon because it's a broader issue of access to justice, and very specifically the access to legal representation in cases where the mandatory death penalty is being applied. And I'm not going to speak more to this because there are many more people on this panel who've got much more in-depth knowledge of this in the Kenyan context. But I think that this is an important point. But whilst we're also still maintaining that that fight for the universal abolition of the death penalty, and as Mr. Kinyua said, starting by removing the mandatory nature, but still continuing a strong trajectory towards the actual abolition of the death penalty in law in Kenya. Thank you.
Thank you so much, Ms. Lee. Your insights are quite invaluable. And just to move towards Malawi, where they've actually made remarkable progress in the resentencing project. On 27th, I think on 27th April 2007, the High Court of Malawi ruled in the Kafantayeni case that the mandatory imposition of death for the offense of murder amounted to inhuman and degrading treatment or punishment in violation of Section 19(3) of the Constitution. The Supreme Court of the Court of Appeal affirmed the decision in this case, and in the Jacob case 3 months later. 3 years later, in the Yasini case, the Supreme Court ruled further that all murder convicts who had been sentenced to the mandatory death penalty were entitled to resentencing, even if their death sentences had subsequently been commuted to life imprisonment. Ms. Ruth Kaima, as a litigant who has actively engaged in representing death row inmates, what are the judicial and legal approaches undertaken in Malawi towards implementing the resentencing project? Welcome, Ms. Ruth.
Thank you very much. As it has already been alluded, indeed, in Malawi, the mandatory death penalty was abolished as it was deemed to be unconstitutional. So following the abolition of the mandatory death sentence, there was need to ensure that all these people, as per the court order in the Yasini case, to ensure that they go for a resentencing. But then bearing in mind that this was something new that was never envisaged in the law, there were a lot of uncertainties as in how we would go about it. Because there were issues to say, okay, since these people were tried in the High Court in Malawi for murder when they were sentenced to death, should we take this as an appeal to the Malawi Supreme Court? Or should it go back to the High Court since it's just resentencing? So the first thing that was done was there was need for a lot of stakeholders to come together, bank heads, to wedge the way forward to say, okay, so how do we proceed? So this whole process was spearheaded by the Malawi Human Rights Commission, and then they brought in a lot of stakeholders, like the Director of Public Prosecution, the Legal Aid Department, the Paralegal Advice Service, CREA. We also had experts like Professor of Law, Sandra Babcock from Cornell University. All these stakeholders came in together, the Malawi Law Society, they all came in together to see how best we would approach this. So the first thing that was done was to engage the Chief Justice, who set up a committee. So the first thing that the committee did was to come up with guidelines to say, okay, since this is a resentencing hearing, what guidelines are going to be followed? So the first thing was to create the guidelines. But before creating the guidelines, these stakeholders needed to see that which were the areas that needed to focus on. So there were basically two objectives, two areas that we need to focus in to ensure that the resentencing process or resentencing project rather was a success. So the first part was to look at the legal perspective to see, okay, if we want all these prisoners who are on death row due to mandatory death sentence, for all this to be resentenced, what is required? So the first thing was the developing of the guidelines. And then also we needed to ensure to see, is there enough human resource? Let's say like lawyers, are there enough lawyers to take up all these cases? Because by the time that the Kafantine was, the case came into force, we had about 192 prisoners who were on death row. So we needed to make sure that we have enough resources in terms of lawyers? Do we have enough paralegals to help with the interviews, to help with the research, tracing of the files of all these people? And then on the other hand, we also had to say that, okay, if these people are going to be resentenced, chances are high that others will be given sentences, and maybe bearing in mind the time that they've already spent in prison, they'll be released immediately. So how are they going to reintegrate back into society? So we also had to look at that. So we needed to look at issues of civic awareness, meeting the chiefs, preparing the community, making them understand to say why someone they had deemed to be awaiting execution is released. So we also needed to look at that angle to ensure that much as this was like an achievement in the legal profession, but we needed to make sure that there won't be a backlash in the community. So there was also need to prepare the communities that when these people are released, they need to go into a community whereby they will be accepted, they'll be integrated. But also, we also need to look at the area of now these inmates who were on death row. Others were on death row maybe for 20 years. They also needed to be counseled, and they also needed to be prepared, maybe to be given like special skills so that they would know where to start from when they go out. So there are all these areas that had to be looked into. So after developing the guidelines, we now needed to see how best we go about these resentencing hearings. So after developing the guidelines at least are the ones that at least gave the direction to see how we would go about it. So the first thing that the guidelines said was to ensure that as much as possible, the judge that had tried the actual murder case should be the very same one that would try the sentencing rehearing. And the guidelines had also stated that this meant that these rehearings would not be taken as an appeal, but it will simply be like a rehearing of the same cases, but only on the part of the sentencing part. So the hearings, basically, they took the normal adversary system whereby the state would bring in their case, they would bring in why the aggravating factors, why they think maybe the sentence should be whether life imprisonment, whether the person should be given years. And then on the other hand, even the legal aid lawyers or maybe lawyers, pro bono lawyers from Malawi Law Society who were representing these prisoners who are on death row would also give in their side to say the mitigating factors. And then in the end, the judge would come up with a sentence. But then aside from this, from an informal point of view, there are also what we are called sentencing bargaining, more like what we do in plea bargains, but these were called sentencing bargainings, which was happening between lawyers for the state and lawyers for the prisoners, either from legal aid or from the Malawi Law Society. They would maybe basically bargain, and they would agree to say, okay, maybe we would be comfortable if this prisoner would be given, let's say 10 years. So when they go for the rehearing, when they're giving in their factors, the mitigating factors or aggravating factors, in the end, the state would actually make a proposition to say, in this case, we were thinking that maybe if this person in this case will be given 20 years, and then maybe the legal aid will say 15 years, and then in the end, the judge now will come up with the sentence. So the guidelines were the ones that really helped a lot because they had mapped a way forward on how the legal process on resentencing rehearings would be done. As I've said, this was something that had not been done before. But then there were also other challenges that were faced during the sentence rehearing. For example, one of the main challenges was the missing of files. Almost 60 or maybe 70% of these files for these prisoners could not be traced, which meant that the court, as well as the lawyers for both the state and the defense team, did not have much. Usually they'll just have the information maybe on the prison commuter warrant, and then maybe just brief facts. So it was an issue of saying, okay, there are no court records. So how do we proceed? This is not a full trial. It's just sentence rehearing. So they had to come up with guidelines. So some of these guidelines were in those guidelines that were developed by the Chief Justice, but other guidelines were coming in during some of the resentencing hearings. So maybe the hearings that happened at first, the judges would actually come up with principles or maybe procedures that think they would be befitting or during the sentencing hearings. So for example, on the issue of missing of files, it was actually one of the sentence hearing cases, like in Republic versus Toboa. And also another case, Republic versus Dembele, whereby the court stated to say that, okay, where there are files missing, then the court would be bound to borrow a section under our Criminal Procedure and Evidence Code under section 260, which allows the court or the lawyers for the other parties to bring in evidence, aside from the evidence that was in the court record, that they would feel would actually help in informing the court when coming up with a proper sentence. So some of these evidence that were used included information that was gathered during the interviews that were conducted by the paralegals, as well as students from Cornell University and also from the University of Malawi, and as well as the lawyers from the interviews they had with the prisoners and from the research they had, and also from interviews that they had maybe with family members of these prisoners or even the communities, just to gather on how they think the offenses had occurred. So they also use this information to inform the court when coming up with sentences. So at the end of the whole process of sentence rehearing, more than 150 cases of prisoners who were on death row were heard. Most of them were sentenced to years. There are others who were released immediately, and but the good news was there was no one who was actually resentenced to death. And following this process of sentence rehearings, there were a lot of principles that were developed or basically established for the court herein forward to be following when considering imposing sentences to people who've been sentenced to death or who are on murder. So some of the notable principles that were developed from these cases during the sentence hearings were that much as we still have the death sentence in our laws, but this sentence should only be given to those worst offenders who will be deemed like rarest of cases. And also, they had also stated that in cases whereby maybe offenders are mentally ill, or they are child offenders, or maybe they have health issues, the court basically said that these categories should not even be considered to be given the death sentence. But also the court stated that for those who've stayed in prison and maybe for longer periods, and there's evidence that they've gone through different kinds of torture in prison, or even those who've experienced longer time for their cases to be tried, it would not be ideal, and it would not be just for these people to be considered for the death penalty. So from all the 150 cases, more than 150 cases that underwent sentence rehearing, as I've said, none of them was actually given the death sentence. Most of them were commuted, and actually others were released immediately. A few were given life imprisonment. And the other interesting factor is that all those people that had undergone this sentence rehearing and were released, there has not been any record of a single case of reoffending. So basically, all these prisoners were able to reintegrate fully back into society, and actually some have even attained roles like being village headmen, which basically just showed that the resentencing process actually brought justice to a lot of prisoners who had been condemned to death. if the death sentences were executed, probably we would have robbed some of the people who had the chance to actually reintegrate into society, to change into better citizens of the society.
Right.
But
Thank you
hello?
very much. Hello, hi. Thanks very much, Miss Ruth. I don't want to cut you off. I want to hold it at that positive note so that we can pivot back to you in a bit after we have a few more contributions from the panelists. I do this in the interest of time so that we ensure that all panelists do get to make the contribution, but we will have another opportunity to come back to you just so that we can tie the presentations together with Mr. Wilson Kinyua. So allow me to move to our next panelist. Hearing from what Malawi has said and the positive note that they have left us on, which is on most of the persons who have had their sentences resentenced rather, have been reintegrated into society and are good contributors to their community. How then do we say that the death penalty should be something we uphold in our African societies? And as you're thinking about that, it would be remiss of me to invite you without first congratulating you on your appointment as an expert member to the Commission's Working Group on Death Penalty, Extrajudicial Killings, Arbitrary Killings, and Summary Executions. So with that new appointment comes new responsibilities. So thank you very much for being with us. And my first question to you will be, what is the working group's contribution towards strengthening regional commitment to abolish the death penalty in Africa? Over to you, Kevin.
Thank you very much, Julie. As we commemorate the 18th World Day Against the Death Penalty, the working group has seen a trend towards the abolition of the death penalty in Africa. It continues to grow in pace and momentum. And as of July 2020, 44 countries, parties to the African Charter, had abolished the death penalty in law and in practice. 21 states had abolished the practice by way of enacting national legislation. Of the 12, had also ratified the second optional protocol to the ICCPR on the abolition of the death penalty. 23 have not carried out an execution for at least 10 years. The working group also takes note of positive developments that have been made across Africa, including the decision by the National Assembly of the Republic of Chad to abolish the death penalty for all crimes of terrorism as of April this year, and the decision of the State of Congo to adopt a law authorizing the ratification of the ICCPR, the second optional protocol to the ICCPR, aiming at the abolition of the death penalty. Over the decade, the working group has urged states to legally abolish the death penalty or to consider a moratorium on its use. However, we have faced a lot of backlash from countries like Egypt and Somalia and Botswana, who continue to convict on the death penalty. As of this year, 3 convictions were in Botswana, 12 in Egypt, and 8 in Somalia. And this is particularly concerning when the view with the fact that COVID-19 has brought with its fundamental challenges in relation to fair legal representation on the same. Among the key steps the working group has taken towards the abolition of the death penalty includes 1, the drafting of the protocol to the African Charter on the abolition of the death penalty, which is a long-term project conceived by the African Commission on Human and People's Rights, which came first into being in July 2014, where we brought among AU state representatives, parliamentarians, and the NHRIs and NGOs across Africa, and the draft protocol was officially adopted during the 56th ordinary session of the African Commission in 2015. However, since we drafted the protocol, it has met numerous administrative obstacles in making its way to adoption by the AU. The content of the draft protocol reinforces the commitment of the AU states have made to abolish the death penalty, and if the necessary steps haven't been taken, place a moratorium on all executions until capital punishment can be legally abolished. It is a critical tool in encouraging African governments to openly deal with the issue of the death penalty. The draft protocol, once adopted, would be optional and only apply to the states who sign it. However, a notable obstacle has been brought up in securing a place for the draft protocol in the African Charter, and has been that many representatives are simply uninformed of the protocol, and consequently it remained procedurally blocked at the AU summit since 2016. The reasons for the stalemate are several. One is the retentionist powerhouses like Egypt and Botswana continue to oppose the draft protocol. The visibility of the protocol is poor, and it has yet to be placed on the official agenda of the AU summit. However, to counter this, last year, the working group held a meeting with ambassadors and the permanent representatives of the African Union, whose aim was to raise awareness, identify the obstacles, and generate enthusiasm for the draft protocol to the African Charter on Human and People's Rights on the abolition of the death penalty. The second thing that the working group has been doing is drafting of resolutions. An example is the resolution 136 of 2008, where it called on state parties to observe a moratorium on the death penalty. It also called that states ensure that they guarantee that every person accused of crimes for which capital punishment is applicable benefits from all the guarantees of a fair trial, including in the African Charter and in every other regional and international norms and treaties. It also urges state parties to the African Charter to include in their periodic reports information on the steps they're taking to move towards the abolition of the death penalty in their countries. The third thing is that the Commission has continuously sent letters of concern to states that continue implementing the death penalty. A case example is it sent a letter this year to the government of Botswana for clarification to the Commission on the circumstances surrounding the execution of Mr. Moabi and Mr. Bokayo, and whether their families were duly notified, provide clarification whether they have duly exhausted all appeal processes legally available to them under the laws of Botswana. We asked them to introduce a moratorium on the application of the death penalty with a view to abolishing it and suspend the 6th execution of death row inmates in Botswana. The Commission urged the Botswana authorities to take necessary measures to implement the Commission's resolution 136 of 2008, urging states parties to the African Charter to observe a moratorium on the death penalty, the General Comment 3 on the right to life, and to fully commit itself to complying with Botswana's obligation under regional and international human rights law. We have also commissioned studies on the death penalty, which can be found on the website. The most recent study establishes that for the death penalty to abolish, one of the conclusions was that one of the things is that we need to enact legislation prescribing the death penalty as a permissible sanction. And the other ambit of it would be by subscribing to regional and international human rights mechanisms requiring the abolition of the death penalty and then aligning national laws to those instruments. Any of the two methods is preferred because they make any hasty or political motivated reintroduction of the death penalty as much more difficult. Abolition of the death penalty imposed by decree or by law enacted by a controlled legislature must be suspect because dictators can decree abolition overnight and equally safely reinstate it. By abolishing the death penalty in Africa, states will be complying with their commitments under the African Charter and protect the right to life and human dignity, while enabling the continent to keep the pace with the global trends from capital punishment. As I finalize, some of the things that the civil society can do to hasten the process would be to strengthen at the national level the legal framework protecting the right to life and dignity by supporting the adoption process of the draft protocol to the African Charter on Human and People's Rights on the abolition of the death penalty in Africa, and continue advocacy at the national level for the abolition of the death penalty, collaborate and support similar advocacy efforts at the sub-regional and continental level. Thank you very much. That's my presentation, Julie.
which is on civil society's call. So what and institutional reform about the death penalty in Kenya? I appreciate that Amnesty wears various hats. So you can speak to Amnesty in Kenya and also Amnesty Global around what we have done towards advocating for the abolition of death penalty. Thank you. Over to you, Dimas.
Well, thank you very much, Julie. Amnesty has been working on the abolition of death penalty from 1977. And being an organization with quite a large reach all over the world with 5 million members, where we have employed various strategies to ensure that the death penalty is abolished. First and foremost, Amnesty believes that the death penalty is the ultimate force, or the ultimate form of degrading treatment to human beings, and we call for the abolition of the death penalty, no matter what, no matter the circumstances. So no matter the crime, no matter who the perpetrator is, no matter how grievous what was done happened. In Kenya, we have done several initiatives to basically give awareness to members of the public and policymakers in terms of the nature of the death penalty and why we believe that the death penalty is an affront to the right to life and a form of torture, cruel and inhuman and degrading punishment and treatment. Over the years, we've seen, as other panelists have said, we've seen a trend on how the death penalty is being abandoned globally. And this is not only happening in Kenya or Africa, it's happening in the Americas, it is happening in Europe, where I think there's only one country that still retains the death penalty, and also in Asia. And part of this education is geared towards making people understand that the death penalty itself prevents someone from reoffending. In fact, the very nature of a person undergoing trial and being in prison means that they've been removed from society, so that that prison sentence has basically removed them from reoffending, and they are, depending on the veracity of the crime, there are other sentences that can be given apart from the death penalty that will ensure that that person pays for what they did. We also say that why is it that the government itself or the state decides to do what the person they are punishing did? So do we rape rapists? Do we terrorize terrorists? Do we rob people who rob others? So what is unique about the death penalty that we want to kill a person who perhaps is accused of killing other people? We encourage that shift in thought. There's also a claim that that the death penalty is a deterrent because it's a severe form of punishment. Well, in this one, we are categorical that there's evidence that shows that, in fact, societies that retain the death penalty do not necessarily see a drop in crime. So you can give an example of Canada and the USA, where Canada abolished the death penalty and the crime rates are relatively lower. But when you look at the United States, which several states still retain the death penalty and do it in practice, you find that the crime rates do not necessarily go down. So it's not really a deterrent. So an execution cannot be used to condemn killing. It is a killing in itself. And why should governments be based itself like that? There's also a claim that it should remain because the public supports the death penalty. So in this, first of all, we would like to approach policymakers, first of all, to make them understand the nature of the death penalty, how it's an affront to human rights, but also to give them a responsibility to steward their societies towards a more human rights respecting approach. It cannot be that because a society believes something repugnant is good, that now the government will just support it wholeheartedly. So this will challenge states to rise above these sentiments and follow the trend, the global trend that has found that the death penalty is the ultimate cruel, inhuman, degrading treatment and punishment, and also an affront to the right to life. So when we look at fair trial with regards to the death penalty, even under the Kenyan Constitution, we realize that the right to fair trial under Article 25 is one of those rights that cannot be limited under any circumstances. And the right to legal representation is a very important cog in ensuring fair trial. So here we really, especially in fact this year, this is our theme, that fair trial and representation is necessary as an obstruction to death penalty, and especially in retentionist countries or countries that still have the death penalty in their statute books, it becomes the first step in preventing this human right violation. And this legal representation must be quite effective, and if possible, must be one that has been chosen by the person who's accused. According to international human rights law, and knowing that that people continue to be executed in the world, we advocate for fair trial so that these people can have a fair shake to prevent them from miscarriages of justice, so that there are bare minimums that must be provided by the state as per international law and various constitutions. If you look at our Article 50, provides that a person must be given, must be informed of what they are being charged, must be given material, must be given a chance to defend themselves, must be given legal representation and other things. So these are the bare minimums that we support, especially with regard to retentionist countries or countries that still have the death penalty in their statute books. So we are constantly trying to build coalitions with bar associations, with organizations, with influential people. Also engage with policy makers, legislators, and this is how we have also plugged into the domestic process that is going on in Kenya on resentencing, and we look forward to the implementation of the recommendations that were given by the task force. So our major partners include the National Commission on Human Rights, which was a secretary in the task force. We also are in talks with the Attorney General's office, and we work with the African Prison Project and Crime CPOA also, and also Wilson Kinyua's organization, to shed a light on these issues and to also push for a more human rights compliant society. This year, we've had 2 cases that we are really advocating on, one from Iran and one from Saudi Arabia. And the first one is the Bazan Nasrallah Zadeh case, where a member of the Kurdish community, who is a Sunni Muslim, was arrested in Iran, and his age was 17. So after he was arrested, he was tortured by being held upside down, by being subjected to electric shock. And he was subjected to this for 3 years. So after 3 years, he was given a court-appointed counsel, but the counsel was not given time to go through the case. So when the case went to court, he was sentenced to death. On appeal in 2015, so he was arrested in 2010. The court upheld his sentence, and so the word we're getting that is that he's being processed to be executed quite soon, and we are rallying our international supporters to write letters to petition the government to stop this this killing. So in this case, you see one ingredient is that he was a minority religiously and ethnically. We also find that he was subjected to torture. We also find that he was underage. So he really had no chance in whatever legal environment that he would find himself in. The other case is a Saudi Arabian case where a Nigerian immigrant who had just arrived in the country and had gone to a car wash where a lot of immigrants, especially of African descent, usually wash cars. And the police and one police officer and some armed individuals came there and started harassing them. A brawl ensued and an officer was killed. So he was arrested alongside other people, but for some reason, him and other 12 people were tried. He was subjected to torture again, held without trial, first of all, between 2002 and 2005, and was forced to sign a confession. So he appended his thumbprint on this confession that was in Arabic, which he does not speak or understand the writing. And so when he went to trial, there was no legal representation at all. His consular, the Nigerian embassy was not consulted. He was not given facilities to translate Arabic, so that the trial was just going on and he's just looking at them, and he was sentenced to death. Finally, the 12 people who were with him were given varying sentences, most of them 15 years. So most of them walked out of prison a few years ago. But for him, his case has gone through all the appellate processes. And the trick is that under the Saudi laws, there's something called blood money that members of the family must agree to remove the death sentence. And the last born of the officer turned 18 this year. So we are apprehensive that if that last born refuses the blood money, this individual is going to be executed probably this year. And we are also really campaigning around this case. So in this, you find that the ingredients are what? That he's an immigrant, so a vulnerable person, no legal representation. And you see what ensues is a miscarriage of justice. Thank you very much.
Thank you very much. About the Kenyan situation and also the international perspective. Indeed, Kenya to the task force recommendations on and footing for us to even look at how to go about of the that came from that. Shedding little of abolition of the death penalty and during the course, participants have been writing to us in the section. Will that
we can
away from this conversation? So I will ask a question, you respond to it, and also and take away from the entire session. To kickstart our question and answer session, I will turn to the Africans. Kevin has talked about the work that the Commission UN level and domestic level engage us on that particular.
And Jury, I didn't hear you. I don't know whether you are addressing me. You're not audible.
I also can't hear you.
Yeah, I think it's a problem with the mic.
I also didn't hear anything.
Yeah.
Okay. Sorry.
All right, let's test our audio now. Can you hear me from the studio? And all these things have taught us that technological issues do happen. So we are glad to be back. We were now wrapping up from what we have just discussed. And one thing that we have done is engage with our participants and look at the questions that they have been sending us. We need to now dissect some of these questions. And the first question is to you, Ms. Lifang. You have spoken about the robust UN movement and the global trends. Kevin has come in and talked about the Africa Commission movement and the recommendations on abolition and moratoriums. And Dimas has set the context on the domestic movements and the way forward. How are all these coordinated at the UN level, regional level, and domestic level? And how is the UN spearheading this coordination? Over to you, Ms. Lee.
I think that it's also, in the sense that it's important for all of there to be movement at the different levels, whether it be from the international level, regional level, and then at the domestic level. In terms of coordination of all of these efforts, I don't believe there's actually a formal coordination mechanism. I think that there's a clear direction that we're all moving in and that we've all spoken about. There are annual conferences generally on the death penalty at the global level. There is an annual report by the Secretary General on the death penalty that goes to the Human Rights Council, and that draws on all of the efforts which are going on at the country level. and also reflects regional level efforts. So that gives a little bit of the picture of what's going on. But in terms of all of the different initiatives to move towards abolition, there's no formal coordination of these, because I think that these are owned at the national level, these are owned at the regional level, and there's a very important role to be played by different actors, as we've all been talking about, not just by the states, by governments themselves, but by civil society actors, to be able to really push for this at the different levels. I hope that answers the question.
Yes, it does. Yes, it does. And unfortunately, you didn't catch it when I said it because we were having a few challenges. But what I'd also said is, as we answer the questions, we can do takeaways, take homes. What is your rallying call on the access to legal representation question for persons who are facing the death penalty from the Office of the UN, and from you personally, seeing that you're a human rights champion and activist in this space? So what would be your takeaway and your closing remark on this particular issue?
My closing call is for us to continue to push for the abolition of the death penalty in Kenya. I would also say that as we are still maintaining that push, that we do really look at the issues of legal protections and fair trial guarantees, and ensure that legal representation is provided to those who are facing trial for offences that could attract the mandatory death penalty, because it's clear that this is critical for access to justice, for rule of law. So, but at the same time that we're still maintaining that push towards the abolition of the death penalty as a whole in Kenya.
Thank you so much, Ms. Lee, for your remarks. I will move to Ms. Flora Bidali. Ms. Flora Bidali, there's a question that has actually come in, and this participant has actually drawn from the perspectives from Malawi as provided by Ms. Ruth Kaima. And the person has asked, drawing from the perspectives shared by Ruth on implementation of the resentencing project in Malawi, in our case, as you have rightly put, we will be utilizing paralegals. What are some of the concrete suggestions on how this engagement will be rolled out, owing to the fact that we have a large cohort of prisoners who might be resentenced in light of the Muruatetu case? Over to you, Ms. Flora.
Thank you. I hope you can hear me. Now,
yeah.
The paralegals are people who will have been trained on how to go about in access to justice when it comes to this, like the Muruatetu case. Paralegals are available on the ground, and since we are working with them, accrediting them, and empowering them to understand the system so that we will be able to reach those in lawful custodies. Even at community level, the families of those in lawful custody, the paralegals are the ones to create awareness on services that can be rendered to them by the state at no fee. So the paralegals are an important component in access to justice in as far as the National Legal Aid Service is concerned. And working with them will achieve at least most of what it is that we want to look at with this death penalty. Over to you.
All right. Thank you very much, Ms. Flora. You have not given us your take home and your closing remarks and your rallying call. So we will pivot back to you just for that take home. What do you wish to say as the National Legal Aid Service, as a rallying call around access to legal representation for persons who are, yes, convicted of the death penalty, but for general persons who might be listening to this and are wondering when the National Legal Aid Service will come to their assistance? So what will be your rallying call or your take home from this discourse? Please unmute your microphone.
Hello? Now, my take home on this is, as the National Legal Aid Service, we are rolling out these services. We've already started doing it. We have a toll-free line. If Julie allows me, I can share the toll-free line here. And this toll-free line, it would be placed even at prison level. We are already receiving calls. We are having radio talk shows to create awareness on this. And we hope that we will be able to partner with like-minded people in the justice system so that we can reach out to all who may require our services. As I said earlier, we are available in different counties, and our toll-free line being 0800 720 640 is there for anyone who requires our services. We use a lot of referrals in order to engage as many people as possible to render services in the fastest way possible. Over to you, Julie.
Thank you so much, Miss Flora. I will go to Miss Ruth Kaima. Masi Wamboi is actually asking, and she's grateful that you've given us an opportunity to hear from you, particularly as you were directly involved in the resentencing project. So she's asking, you have rightfully stated that there were a number of challenges whilst implementing the resentencing project in Malawi. You have specifically spoken to missing files, a huge challenge here in Kenya. So what measures should be undertaken to ensure accountability in the process? Thank you.
Thank you. You can hear me? Okay, thank you very much. As I've said, indeed, the missing of files was a very huge challenge in here. So some of the measures, the best measures that would be best to be taken is, first of all, is to actually come up with proper guidelines. And this should be done in collaboration with the judiciary, with the lawyers, from the state, to actually see, depending on what the law of Kenya says, on sentencing guidelines, and then you will now try to relate that with the sentencing process that you'll be doing. As I indicated here, it was helpful because already in our laws, we had a section that had provided that the court could actually look at other evidence that was not in the actual court record, of course, with safeguards provided. So maybe the best would be to actually come up with those proper guidelines, that before you start rolling out the project, you would actually already know that if we come across the challenge of not having court files, how best can we mitigate this? But also, as I've indicated, you could also try to make more research in the lives of the prisoners as they're in prison, but also the communities, where they're coming from. The chiefs, the leaders, they always giving insight on maybe how the offenses occurred, and also how the community would actually feel if those people are brought back to the communities. So you use all that and maybe the little information you have from the prison record to now try and balance to see how best can justice be done. Thank you very much.
I go. Thank you. Thank you so much, Ruth. Actually, there's someone who's been constantly asking a question, sending it to Kevin, asking Kevin that he's actually excited to see a young member joining the committee, and is thrilled that the youth are actually well represented in the committee. So from Paul Otieno, Paul is asking us then, how is the African committee, the working group on the death penalty, plan to engage civil society organizations in the regional movement on the abolition of the death penalty in Africa?
So as I have stated before, so some of the things we have been doing is even in the drafting of the protocol to the African Charter on the Abolition of the Death Penalty in Africa, we did involve civil societies. And now it's for us to work in our national levels to ensure that we do a lot of advocacy to have the states discuss it at the AU summit and it's passed. I know for Kenya, for example, we'll face a lot of issues because even on during the third universal periodic review, where they gave their feedback on the recommendations given, they stated that even in 5 years, they don't foresee Kenya abolishing the death penalty. So in Kenya, there's a lot of advocacy and sensitization to be done. And a lot of, I think people are still unaware on what all this means. And so working together in terms of advocacy, that would be the best way. And also advocacy for the abolition through strengthening of the national framework, the legal framework for protection of the right to life. I think that would be it.
Thank you so much, Kevin. And I will rope in what you have highlighted with the next question, which is going to Dimas from Sharon. Sharon is asking Dimas that a lot has been done, a lot is going on at both the regional level, the national level and the international level. How are international non-governmental organizations working with grassroots organizations to actually empower them to contribute to the death penalty movement in Kenya?
So every year, Amnesty International at the International Secretariat releases an annual report that outlines the number of executions by country. And then we are an international organization with a Kenya office. We disseminate that information to our partners here in Kenya. For example, Wilson Kinyua's organization, Africa Prisons Project, Crime CPOA, and work together to roll out activities and initiatives and engagements with the public and stakeholders that is evidence-based. So there is a robust way that we work with local civil societies and other partners with an international character, including the regional bodies. So there is a connection that is not necessarily coordinated, but it exists between international bodies, the domestic offices, and the local, national, and community organizations. Last year, we held a screening of When They See Us, which highlighted the case of the Central Park 5. And we did it in Dandora and we brought together criminal justice actors, prosecutors, judges, former inmates, and criminal justice experts to have a discussion on what happened in that case, which was highlighted earlier, but the one correction is that the lady did not die. She's still alive right now. But because the 5 gentlemen were young, Black and Hispanic men in New York, the city was baying for blood. And this is the kind of irrational calls for immediate justice that actually cause injustices. So first of all, they were young, they were not represented by lawyers in the initial stages of taking statements. Their parents were lied to. And so in that case really showcases how the lack of representation and fair trial can be used to deal with vulnerable communities. And we brought that to the community and had a very fruitful discussion on it with Kenyan organizations, with domestic social justice centers from various parts of Kenya. So there is an initiative to have a collaboration between international, national, and domestic organizations and community organizations. Thank you.
Thank you very much, Dimas. Thank you for joining us for this session. Thank you for telling us how you will be engaging the CBOs. I think it is important for us to always remember that even as the statistics were shared, most of the young people are the ones who are affected by the unfortunate instances owing to their poverty owing to their youth and owing to the fact that they don't have legal representation. It is all a situation that then becomes a very bad one owing to all those circumstances. So it is important for us to disseminate information and empower the young people to take this conversation forward, even in their communities. I now wish to have a final question and closing remarks from Mr. Wilson Kinyua. Owing to your past experience, you're a hero, you're a champion, and you have had an opportunity to go forth and be an advocate. We cannot say that this is the situation with all the people who unfortunately leave detention facilities and into the normal community. How would you rally civil society? How would you rally government? How would you rally the international institutions that are represented here? What deliberate action should we all take to ensure that access to legal representation is afforded to persons who are in incarceration, on death row, and even those who are facing long sentences, really, that could be easily resolved by the input of an advocate? So what would be your rallying call to all of us here as panelists, as participants, as advocates, and as human rights champions? Over to you, Mr. Wilson. Please unmute your microphone.
Yes, sorry for that. Hope you're getting me.
You're perfect.
Well, I want to say this, that we need to abolish death penalty. That is for sure. We need to abolish death penalty. But all the abolitionists, Amnesty International, and all those people who are supporting, must also be able to define a contour. Like Kevin has said, we need to devise a contour of disseminating information and the collect information to the people who need them to support this kind of reform. We need to get them the right information. We need to design a system of giving them the right information so that they can support that reform. Because the one question they will always ask you, the community will ask you, the intention of punishment of sentencing, is to punish, to deter, and most importantly, to protect the public. So what is the alternative? We have always have to deal with that question. And we cannot say life sentence, we cannot say certain time, a certain year. So what is the benefit to the community? That is the bottom line. That is the bottom line question we must answer. And that is why I want you, or I'm asking you, I'm pleading with you to support the dialogue of criminal justice system that will make the objectives of punishment effective. That is, and I said, we must have a system of legal and institutional reforms that will ensure only the guilty goes to prison. And then when we have the guilty in prison, how then do we get them transformed in a manner they do not relapse, and number two, they do not turn agents of recruitment and proselytization of young people? Because today in prison, if you ask the statistics, out of all the death penalty convicts, or the whole population of prison, over 90% are first offenders. Where do they come from? They are people who are recruited by those few who are not properly transformed and rehabilitated from prison. But how does that come? We must not buy these, public relation that we have people, all the people coming out of prison are reformed. Somebody rightly asked the question, are all inmates like Kinyua? Do they leave prison feeling the same way, empowered like Kinyua? If you go out, there are a lot of local charitable organizations that are hosting ex-convicts, providing shelter, food, and clothing, like beggars. Why? These are people who have been trained. They've been empowered to be able to do this for themselves, to feed themselves. Why? It's because we have a disconnect between between the rehabilitation itself and the integration, effective reintegration. We must support an effective method of crime management and crime control, so that then this is a good answer to the people as an alternative to these kind of harsh punishments. Number two, and this is directed to Florence. It is true, and it is beyond contention. There are a lot of miscarriage of justice because of lack of proper representation. There are a lot of things happening. People are not getting an opportunity to prepare their defense because they cannot have, disclosure of evidence because they do not have money and they have no lawyers to be able to ask this for them, because after all, the Constitution must prevail. Money will not, be compromised, will not compromise justice. The young people, the minors who are going to prison because they have been charged of capital offenses, or they have been co-charged by people of majority age, and the children's court cannot prosecute that matter. And the default is that they will end up in the main prison. And the protections in the Children's Act have not been dispensed with. No lawyer can help this because in the first place, the children were not represented. And it is not enough to say that now that we have the national legal aid, they will now be represented. We know, and I have attended a forum where over 80% of the funding of the national legal aid is going to administrative work. Until you turn the table, that fraction, only the smallest fraction should go to administration, and the bigger funding should go to the representation, not the other way around. So that then we have a lot of people being represented. You will agree with me, there are people today faced with death penalty, probability of death conviction, and they are not represented in the law court. You'd rather give me a lawyer when we are laying the foundation of the case than give me a lawyer when the case has already been destroyed, the foundation has already been destroyed. Those are the things. So I am happy. I've been working with the Amnesty International. They've been looping me in the dollar event recently in the lobby against execution of a minor in Southern Sudan. And I'm happy to work with all those other organizations who feel maybe this exclusive information is what they need to turn the tables. We can be able to do this through ICJ, through all those other organizations. We can be able to help abolish the death penalty and get it right in the judiciary and in the prisons. So those are my passing shot.
Thank you very much, Kinyua, and thank you for telling us how we can continue this discussion, how we can create impact, how as civil society we can do more. And I agree completely, we need to do more because there are people who are relying on our work for them to get freedom from the situation that they're currently in. You have actually said that we need to engage in the criminal justice process, and I'm happy to say that ICJ Kenya is a member of the Criminal Justice Reforms Committee by the National Council on Administration of Justice that is looking at a holistic reform of the criminal justice system. With it, we will be looking at the court process from entry into the court system, access to legal representation, certain laws that ought to be decriminalized, issues around reintegration, probation, and all those issues that you have mentioned, it are extremely pertinent. So we are grateful and we are happy that what we will be doing is extremely important and especially will have an impact on lives of persons. So access to legal representation for persons facing the death penalty is a conversation that we will be continuously having on our various social media platforms in light of the fact that we are here to commemorate the 18th day against the death penalty. We will therefore invite you to further this discourse in those spaces. Use the Amnesty International Kenya social media tool. Use ICJ Kenya social media tool. Talk to us, engage. There are other countries that will be having similar discussions today, tomorrow, and next week. So plug into those conversations and hear the various milestones that are happening in Africa and across the world. I wish to thank our panelists on behalf of ICJ Kenya and the participants for your time and invaluable contribution to this discussion. I thank you so much for sparing your Friday morning with us, and I hope that you have learned something from each and every one of the people who have presented today. One thing I will take home is poverty is not a crime, and neither is it a death sentence. Thank you all, goodbye and good day.